We're here with Donna Berkelhammer from Legal Direction, and we're going to talk about trademark law, an introduction. There's much to go through on trademark law, but we will get enough information to scare you or to guide you in the right direction at least.
So that you understand both marketing and legal what a trademark is. So
exactly, that's a better way to put it. I will remind everybody, if you have questions during Donna's presentation, put them in the chat. I'm sure she'll stop every once in a while to ask if you have a question. If you have a question and it's not in the chat, you can always unmute and say the question. But let's just keep it as organized as possible so we can get through the content. I like to keep them in the chat, and that way we can work on them as we go. Sometimes I can even answer a question if it's something simple or guide you towards a resource. But keep those questions coming in. It's nice to interact with people. I'm going to go ahead and start talking about a few things I just wanted to touch on related to our content. We're always trying to make the route towards a webinar or towards a piece of content as easy as possible. And if you wouldn't mind putting in the chat a comment or something that you find difficult, or it was very easy to find, it was accessible, or it wasn't, a little bit of your experience getting to this piece of content here, just to help us understand where you got it, where you saw the invitation, or how it would make it easier for you to get on here. We are a program of the SBA, and so everybody that's in a webinar or that we come in contact with, we want to know about, and we want to be able to say, hey, SBA, we're talking to these people. And that helps us to stay in business. So that is our metric, right? Is how many people we're interacting with. And so we want to stay in contact with you. We want to know how you reach us, how we can reach you better, how we can serve you better with better content or with content more relevant to what you're doing. So if you send us an email or if you put in the chat, just interact however is easiest for you. I'll put all our contact information in the chat as well, so you can reach out to us that way. But yeah, let's stay in contact. Use us. The best way to interact with us, the Women's Business Center of North Carolina, is through our one-on-one counseling sessions, because we speak directly to your business. We understand what you're doing. You talk to us about what you're doing. You share a business plan, or you share your idea, and so we can guide you towards a resource or talk to you directly about what is what you're trying to achieve and how we can assist you in that. So that's all I have. My name is Nathaniel Sperger, if I didn't say that before, and I'm very happy to be here with you guys and with Donna Berkelhammer from Legal Direction. I will hand it over to her, and again, interact with us in the chat, and let's have a great session. Thank you, Donna.
welcome everybody. I'm going to turn off my camera because I work from home and my bandwidth depends on what my neighbors are doing, and I don't want it to be garbled. Let's see. I'm going to try to do that. Okay, so introduction to trademark law. Ask questions as we go. It's hard when we're doing Zoom classes for me to make sure you understand, and I want to make sure you understand. And trademark law is tricky. It's very complicated. There's a lot of different things to know about it. And what I want you to understand from this class today is, what is a trademark? How do I get a good one? What can I do with it? What can I do with it? And how can I use other people's trademarks without getting into trouble? So here's my sad little cow and my sad little brand. But really, trademark is your brand for your products and your services. And if you think about the cowboys in the Old West, like literally, burned their mark into their cows so they'd know whose cows were whose, and they'd make sure nobody stole their cows. That's kind of, in a very rudimentary way, what your trademark is. It is marking your goods and services so that people know who made them, where they come from, what kind of qualities they have. If you go to a law site, it'll say a word, phrase, symbol, design that identifies your products and services, or identifies products and services from a particular source and distinguishing it from others. What does that really mean? I'm going to put a slide up in a minute, and I want you to look at all these logos and think about how you feel about each of them. Oh, I'm sorry. Just so you get a sense of word, symbol, phrase. At the top, you see my logo with the arrows. You see legal direction. You see protecting and supporting today's small business. You see the TM beside that. We'll go into what that means. You see my logo and my name again. And if you look very carefully throughout this presentation, if you see the colors of those arrows, you will see those colors repeated throughout the presentation and throughout my website. That's all a part of branding. So not just the words, not just the logos. But these are a bunch of burger places. You're going to look at these and you're going to have had experiences with all of these, some of these. They're going to be good experiences. They're going to be bad experiences. You're going to go to them for different things. You know, you may be on the highway and it's time for a pit stop. So, okay, kids, we want McDonald's, Burger King, or Wendy's. People are going to have different opinions about that. You may not want to go to this Burger King by your house because it's super slow. That's part of the trademark. How do you feel about this brand? How do you feel about their customer service? I saw somebody, one of my acquaintances on Facebook did a whole post the other day about their child saved up for months and ordered some basketball shoes on eBay. And they ordered them. They got, you know, it's in transit, it's being delivered, it's on your porch, and it wasn't there. And they called Federal Express, got a different person on an 800 number every time that probably overseas in a call center. And they said it was very difficult to explain our local situation and what happened. And they didn't understand we had a Ring doorbell and what that was, so we could see nobody delivered to our house. And they felt terrible about their experience with Federal Express. But when they called to complain to eBay, eBay took them seriously, tried to fix the problem, tried to communicate with Federal Express, tried to figure out what happened, and ended up giving them a refund with no questions asked. And he said the point of that was, you know, one same problem, two different companies, two different solutions or non-solutions, and they're very down on Federal Express and very up on eBay. That is trademark. It's not just these pretty pictures on the screen. It's your entire experience with your products and services. All right. What is a trademark? Word, phrase, symbol, design. The shape of a Coca-Cola bottle is distinctive enough that if you see that shape, you know what's in there. It is Coke. It is not Pepsi. The design of a restaurant, that's a TGI Fridays. I don't even know if they survived the pandemic. I might need to update that. That is a registrable trademark because the elements, like the awning and all the signs inside and the suspenders that the waiters wear, servers wear, those are distinctive and they're particular to that restaurant. They serve as a trademark. It can be a slogan. It can be a sound. The MGM Lions roar, the Old Spice jingle, those are registered trademarks. Color can be a trademark. If you see the Owens Corning fiberglass, it's pink only so you could tell that that's Owens Corning. It has nothing to do with how you make fiberglass. And that little blue box from Tiffany's, you see that little blue box, you get excited. That's a trademark. It designates your product in the marketplace and the qualities associated with your product. That yarn on there is scented. And again, scent is not specific property that every kind of yarn has. So that company set itself apart by scenting the yarn. that is a registrable trademark. There are different kinds of trademarks, and they give you different kinds of protection. The strongest trademark you can have is something that's arbitrary. We don't even think about it now, but when it started, Apple for computers was completely arbitrary, has absolutely nothing to do with computers or technology. I mean, if you think about the Garden of Eden, it's almost like anti-technology, pure, natural. They spent a lot of money identifying Apple with computers. That's an arbitrary trademark. That's also a logo trademark. So that's registrable. The next one is Kodak. That is what we call a fanciful trademark. And that's where you make up a new word for your product. Again, it takes a lot of money to teach people the name of your product and make them understand it, but it's very distinctive in the marketplace because you won't be, is that the sterling cleaners, or is that the gold sterling cleaners, or is that the sterling silver cleaners? It's very distinctive in the marketplace. And you can see that trademark has a word and a logo combined. On the bottom, we have something called a suggestive trademark. Greyhound is suggestive of a really fast bus line. It suggests a quality of your product or service. So these are all strong, easy to register trademarks. You can see the Greyhound has a stylized font and the Greyhound logo on there, just giving you an example of the different kinds of ways you can register things. Next, we have something that's called merely descriptive. Universal Cabinet Company. Universal in design means, in the past, you might have called it handicap accessible. Everybody can use this design. So this merely describes what their company does. We were able to get a registration for this trademark because we did it with the U symbol next to it, but we had to put a statement in our trademark application that said, we don't have exclusive rights to use universal. We don't have universal rights to use cabinet. We don't have universal rights to use company. So a trademark is not a monopoly. Just because you get a trademark with common words in it, you don't get the exclusive right to use those words in connection with your product or service category. Merely descriptive trademarks, you cannot register without some kind of a design element, because all they do is describe your product and there's nothing unique about them, so they're not registrable. And on the bottom, you see something generic. Generic words are also merely descriptive. If you have just cola, the word for a cola product, you can't register it because everybody else in the whole world can use cola to describe soft drinks. Now, I will tell you, trademark and marketing fight at this stage. Trademark department, your legal people want you to use an arbitrary or a fanciful word. Make up something new. Use something completely unrelated to your product. And marketing says, oh, no. Use something that is a quality or trait of your product or service, because then people sort of kind of already know what it is. And you don't have to spend as much money educating them what your trademark is, what your product is, who you are, and it's so much easier. But here's the problem with that. Here are a bunch of trademark law cases where the trademark examiner refused to register a trademark because they said they were merely descriptive of your goods and services. And I will be honest with you, whenever I see a case that's coming out that looks at suggestive versus descriptive, I can never predict how they are going to come out as to what is merely suggestive of your trait or quality or service and what is descriptive of it. So I like to push people out of suggestive marks and into something more unique. I'm going to pause here. Are there any questions? And if you could help me out.
Yes, we have two. One is kind of a comment question. It says, Donna, are you also saying that a trademark can be considered as long-term first impression? So is it like a
Yes.
feeling that you got?
Yes.
Now, how do you trademark that though? I mean, what are you trademarking? Like
well,
you're still trademarking your logo.
A word, a phrase, a symbol, or a design that when people think it, that the feeling they have is what they think of your company when they see that word, phrase, symbol, design.
Okay. The other question is, does a phrase need trademarking? Or can it be?
It can be. Got milk is registered.
Okay.
That gets tricky because you got to make sure you, like, a lot of people have t-shirts that have phrases on them and they want to trademark that. But the businesses, we have all these funny, quick slogans we're putting on trademarks, and none of those represent our company. Those are just basic products of our company. They're not what we do. So Got Milk is the milk marketing board. And that slogan is to encourage people to drink more milk and learn more about the dairy industry. If you have a bumper sticker or a t-shirt, and like the bank on Casual Friday may have a t-shirt with the bank name as the logo. They are not in the business of selling t-shirts. So even though their name is on that t-shirt, that is not a trademark because their service is banking. So slogans are very tricky. If it's like, if you saw on my webpage where I said protecting and supporting today's small business, that goes with legal direction. That is how I practice business. That is how I help you. I protect and I support today's small business. That that I could register if I wanted to. I choose not to, but I could. If I have my legal direction logo and name on all kinds of promotional products, lip balm, keychains. Those are not trademarks because I am not a manufacturer of lip balm, and the fact that legal direction in there doesn't indicate who made the lip balm. I know that's really complicated.
There's another question, but I wanted to just kind of work on what you just said about the previous two questions. Is it, to me, it would make sense to not necessarily trademark anything until you feel like it is definitely gonna become something, right, worth money, let's say, like your company name? Or should you start right from the beginning, say, I got this idea, I want to go ahead and do it, I'm going to go ahead and register this stuff right away?
You can start registering right away, even before you're using it in commerce. That's called an intent to use trademark. You can file a federal trademark application on an intent to use basis. But at some point, you're going to have to prove you are using that word, phrase, symbol, whatever, in commerce to sell your good or service.
And is it a large enough investment that you should think twice, is kind of where I'm going at, if you're starting a business? How much money is it going to take you to trademark your business name, for example, or a phrase?
I think it's going to come down to every business and your cash flow and your cost benefit. If you're heavily investing in a name for your product, I think product names, service names are pretty strong. They'll last a long time. That's a good investment. I have clients who have speeches and presentations, and we've done some federal trademarks for those products. And I don't think anybody has used those for more than 5 years. So when it comes time to renew, we haven't. And I'll get into a little bit more how trademark works in your business and your business plan as we go.
Okay. I'm going to leave the next a couple questions for next break.
Okay.
All
right. So when you're thinking up a name for or picture for your logo, your trademark, the statute has certain things you can't use. American flags, the Olympic rings, pictures or any kind of indication of a president of the United States, living or dead. If you use the picture, name, likeness of a living person, you have to have their consent. So you will have to file a document with your trademark application that says, yes, you can use this person's name. You can't use anything that's scandalous or offensive. You may or may not have been aware of all the Washington Redskins hubbub over, is that scandalous? Is that offensive? It's been up and down in the trademark office, and the team finally just decided to change their name. There was an interesting case recently about a band formed by Asian people that called themselves the Slants, which is also sometimes a pejorative, unnice name for Asian people, but they named themselves that and were embracing that. And initially it got turned down by the trademark office as not registerable, and they appealed and they won. So that's a really hot area. And I put the little picture of Nantucket Island on there. I don't know how many of you know the restaurant Nantucket Grill in Durham. I've always marveled that that's what they named their restaurant, because putting place names in restaurants is very tricky. You can use it if it's geographically descriptive and it's not misleading, but you have to use it in such a way that you're not merely descriptive. So, for example, you couldn't say Durham HVAC Company, because Durham and HVAC 100% just describe your services. That would get rejected because it is merely descriptive. So what we look at is the primary significance of that name a geographic area? Do your goods or services originate in that area? And would people associate those goods from your area? So then you have to have something else there that makes it not completely generic. So Nantucket Grill is not completely generic, but they're not in Nantucket. You know, if they're serving seafood chowder and things like that, it would be associated with Nantucket. But they're not in Nantucket, and the clams aren't from there. They're in Durham. That would be geographically misdescriptive, and that's also not allowed. There are ways to use your place that are protective and registerable. There was a case, Oak Park Brewery in California was held to be geographically okay because Oak Park's a place, but beer isn't known from there, and being in California was okay because it wasn't in the city of Oak Park, Illinois, which is known for being the home of Frank Lloyd Wright in architecture. Something like the Montecito Diet for a magazine, or Catalina Island granola were okay because those things were not from the area where they just picked a name. It's complicated. I'm just telling you, if you're going to use a geographic term in your trademark, work with a trademark lawyer so you don't get a refusal to register. So how do you pick a good trademark? Brainstorm. What words do you like? What word means something from your childhood? Where's a favorite vacation place? What's a pet's name? Something arbitrary, some new word you made up. I have a lot of clients that make up trademarks or company names based on bits and pieces of their children's names. Once you come up with a word, remember that trademarks have to be registered in connection with a good or service. And trademarks are not a monopoly. So you can have similar names with widely different goods and services. Look to see if the domain name is available. If it's not, maybe your trademark is not available. But, you can have somebody took delta.com for airplanes, and you could still have Delta faucets. Trademark domain names, there can only be one .com. And if it's taken, it might not mean anything, but it might. Again, just warning light, pay attention. Trademarks, remember, legal wants them to be very unique, very distinguished, not a lot that's similar. So what shows up when you search it? And then when a lot shows up, is the good or service similar to yours? Where do you look? The U.S. Patent and Trademark Office, that's uspto.gov. You go to the trademark section and you can search trademarks. There are a couple of different ways you can search. So you can do an advanced search where you search the name and a good or service. Again, if something comes up, you need to do more research and see if it's the same or similar. The legal standard for infringement is substantially similar and likely to cause confusion. Trademarks are different than patents and copyrights. Patents and copyrights protect the creator of something new and gives you a monopoly in the market for a certain period of time so that you can commercialize your idea, your invention, your work of art, your photograph. Trademarks are really a consumer protection statute as much as they are to protect the business. Trademarks allow consumers to be able to identify the quality and service and how they feel about the product and get to the person who makes the product they're looking for. So it's a really mushy standard, substantially similar and likely to cause confusion. If you pick this trademark, would somebody else's customers think you're part of their business? This is what came up. This is an old one because a lot of these companies aren't in existence anymore. When I was searching legal direction, there's a legaldirection.org. And when I clicked on it, it was an educational site that was connecting people. It wasn't providing legal services. This woman, Denise Brown, Legal Direction, she's in Kentucky. I'm only licensed in North Carolina. I didn't think there'd be any confusion. Legal Direction on the bottom in the United Kingdom, same thing. I'm only licensed in North Carolina. So somebody with a similar name in England, not infringing. That's the kind of thing you're going to be looking at when you're doing these Google searches. And in case you're wondering why I am the Legal Direction and not Legal Direction, a friend of mine searched Legal Direction in GoDaddy right before I was starting to make sure it was available. At that time, I don't know if they still do, GoDaddy sells searches people do for proposed domain names. And somebody bought that list and got Legal Direction for something like $12. And then when I went to register 2 weeks later, that domain name was taken. I thought, okay, I'm new to this. I wasn't aware. I will pay what I call a stupid tax. And I offered them $500 to sell me the domain name. And they wanted $5,000 for having it for 2 weeks. I said, thank you very much. That's okay. Let me be the Legal Direction instead. I could have been Legal Direction NC or NC Legal Direction. There were lots of choices. I went with this. And then I filed a federal trademark registration. And the next time they tried to sell it back to me, I told them, no, thank you. And you can't sell it to anyone in the United States that's practicing legal services. So let that be a lesson to you. I'm going to pause here because I'm going to go into something else. Are there questions?
There are a couple. So let me go back here. The one is, how do you differentiate trademark, logo, and brand?
A logo. Yeah, a logo is a trademark. You can get trademark rights just by using that logo to identify your goods and services without registering anything. Trademark and brand are largely synonyms. Brand brand is probably a little more encompassing than the trademark, which is the physical name, slogan, word design that you use kind of as a shortcut to remind people of who you are. Brand might be, what colors are you using? What words do you train your staff to use? It's broader than trademark, but they're very similar.
Here's another one. This one is interesting. She says, I am an artist. My name is the name of my business. And my logo was designed using Arabic calligraphy of the word salam or peace. Can I trademark my name and logo?
Yes.
Her name.
Yes, you can. You're just going to have to file a statement that says you consented to using this as your trademark. They don't want you to steal some famous person's name or likeness and file a trademark because it's going to look like they are endorsing you. So if you use an actual person, you have to have a consent.
Very nice. All right. So you can trademark your own name as long as it's not somebody else's name too.
or you have their permission to use their name.
Or you have, yeah. Okay. All right. That's all I see right now.
Okay. So here's something a lot of lawyers don't get. What you register at the Secretary of State for your business name, LLC Inc., is called a trade name. Some trade names are the same as product names, which is where it gets confusing. But some trade names are at the Secretary of State only, and there are no products or services offered under that name. The Procter & Gamble Company is a Delaware corporation. You see that picture on the bottom? That's a lot of their products. Love's diapers, Charmin toilet paper, Cascade detergent. You don't see Procter brand anything or Gamble brand anything. That is solely a trade name. But a lot of small businesses use the same name for their products and their company name. Nothing wrong with that. When you go to the Secretary of State to register, legal direction, all the Secretary of State is going to look for is there already a LLC or a corporation called Legal Direction LLC? And if there's not, they're going to let you file that. They are not doing any kind of a trademark search. They are just doing, can we distinguish you in our database? Or do you have to be Legal Direction Roman numeral 1 LLC or Legal Direction of Durham LLC? So let me show you a really simple example. Silly. I'm Donna McDonald. I want to do McDonald's restaurant. I go to this McDonald's restaurant LLC. I go to the Secretary of State, see McDonald's real estate, McDonald's realty, McDonald's restaurants, McDonald's store. Great. I can file McDonald's restaurant because there isn't anything at the Secretary of State. Correct. There is no trade name called McDonald's restaurant. But I think it should be very obvious to everyone, I can't use that as an actual restaurant because McDonald's would come down on me like 1,000-pound gorilla. So just be aware that if it's available at the Secretary of State, that has nothing to do with your trademark, your product, your good or service that you're going to advertise. Questions? Okay.
There was one, but I kind of answered it. I'll just say it for the benefit of everybody else. It says, is it better to trademark the business name separately from the phrase, shape, symbol, or design? And I answered that everything is going to be a separate item if it is differentiable. Well, that word, I'm not sure if it's a word, but so you got colors, or you got shapes, or you got names, and these are all going to be separate trademarks. Is that correct?
They can be. Like that example where we had to use the U symbol with the words, we did that all as a block because that was the only way to get it through.
Okay.
But they can be different. The strongest trademark protection you're going to get is just the word with no color, no font, no style, because then you can stop people from using the word any way they make it look. And also the way it sounds. I have people that wanted to use cheese for something where it wasn't available. So they decided to spell it CHEEZ. I'm like, that doesn't count because if the customer hears it, it's going to sound the same. So how do you use a trademark properly so that it doesn't become generic? I had a client who told me he wanted his company to be so successful, it was going to be like Google, where you just Google the term. Well, if somebody is using your trademark as a verb or a noun, I'm going to get all English teachery on you. You've lost your trademark rights because it's become generic. It's become what word people associate with that product category. And if you look at that Sanka coffee, Maxwell House, you could see they have Maxwell House, they have that blue design, and then they have the word Sanka and then instant coffee under it. Sanka was the first decaffeinated coffee. It was a brand new type of product. And when Maxwell House went to register the trademark, they actually created 2 words for their product. Sanka, which is an abbreviation for sans caffeine or without caffeine, and decaffeinated. They made Sanka the registered trademark, and they made decaffeinated a word they were willing to let go into the marketplace as the product identifier. So you wouldn't want people to say, let's go Xerox these. You want them to say, let's go make a Xerox copy. Or you don't want to say, let's play Frisbee. You want to say, let's play with a Frisbee brand disc or Frisbee toy. If you look at the Band-Aid and you look at the Kleenex, Band-Aid came very, very close to losing their trademark for it becoming generic. So you see they have the R in the circle over it. That means they're a registered trademark. If you remember on that first page when I showed you my website, I have protecting and supporting today's small business. I have a TM beside it. I have not registered that phrase because I don't know if it's going to change or not, but I want people to know that it's important to me. I recognize I have trademark rights in it. So I put the TM symbol there. I could have put SM there for service mark. Trademark is kind of the all-encompassing word. If you have a service, you can call it a service mark or a trademark. But the TM or the SM means it's not registered federally. You see that Kleenex box. A lot of people use the word Kleenex for tissues. Kleenex also fighting very hard to not be generic. So it's hard to see on that package, but that red circle, there's an R in a circle, and underneath the X, it says brand tissue. So your trademark is always an adjective that describes something. Sanka instant coffee. Kleenex facial tissues, Band-Aid brand adhesive bandages. You always want to write your trademark in a way that it's set apart from other text. So maybe you have, Texas Pete, all capital, hot sauce, or Texas Pete is in italics, or you put it in quotation marks, so it's not the same. And it always has, Old El Paso salsa, Coca-Cola soft drinks, Tranquility brand mountain water. You don't let people use it as a possessive or a trademark. Like, let's go play with some Legos. Let's go play with Lego blocks. You should all be so lucky to be so famous to have these types of products. And remember, it's always an adjective. It always comes with something after it. Kodak cameras, Jeep vehicles, Levi's jeans. Questions?
So I have a question, and is why is this? Are you saying that we do not want our brand to be associated with the product in that way, like Kleenex and Band-Aid, and Google?
You don't want your brand name to become the generic word for the product. Escalators was a brand name. It was walking stairs. Styrofoam was a brand name. They have lost their distinctiveness in the marketplace because people associate the product with the brand name.
So aspirin, in the case,
aspirin. Go ahead.
No, I was just in the case the examples you have in the slide. Then Band-Aid brand adhesive bandages. what are they gaining? Because I mean, a Band-Aid is a Band-Aid nowadays, right?
Yeah, they're trying really hard to.
So that's just them trying. Okay.
That's corrective advertising. Kleenex too.
I think it's great to have your product become the product, but I'm sure there's reasons not to. There is one question here. It's kind of a comment on the previous question that it says it's on the person that wanted to trademark their name. It says they know of a person who has the same name and has an art gallery as well. Does this mean she cannot trademark the name? She has not found the trademark name.
It's complicated, and we would have to look at specifics. It's possible she couldn't, but not necessarily.
Okay. Yeah, that's a legal talk to your lawyer situation and investigate, I guess.
All right. Perfect question. Perfect segue. 3 types of trademark protection. If you just use it, common law trademark rights, you get the exclusive right to use those words, slogan, logo, whatever, in your area of actual geographic use, plus a reasonable zone of expansion. Nobody ever knows what that is, so it's really hard to stop other people from using similar trademarks if you only have common law. It's possible, it's just harder. State registration gives you exclusive rights to use the trademark anywhere in North Carolina, no matter where you're actually using it. And federal registration, if you're using your advertising your product in interstate commerce, website usually gets you there. You can get a federal registration and have exclusive rights anywhere in the country, no matter where you're actually using it. So yes, you do get some rights just from using your trademark. They're not very strong. Recommend one of these registrations. The filing fee for a state registration is $75. The filing fee for a federal registration is $350. Now, remember I told you you have to register in connection with a good or product. That's going to be $75 and $350 per class. So the trademark law in the statute divides names, I think 48 different classes of goods and services. And when you're trying to describe what your product is, it'll tell you what class it's in. Sometimes you end up in more than one class and you'll have more than one registration fee. That's something you'll know going in, how many classes you're in. They're completely arbitrary. I'm sorry, they are what they are. All right, so what is infringement? You cannot use someone else's trademark or something substantially similar in a way that is likely to cause confusion to a typical customer. Remember, this is from the customer's point of view. If I saw your product side by side with your competitors, would I know which one you made? And excuse the terrible photography. This was me almost getting thrown out of the dollar store one day as I was taking pictures. Liquid Plumber on the left is a nationally known brand. Mr. Plumber on the right is the dollar store equivalent. Super similar. They look alike. They have similar names. Plumber is very prominent in there. I think almost everything in the dollar store is infringing or bordering on infringing because it's supposed to look like the national brand and it's not. Again, would you expect something in an orange bottle in the dollar store to clean as well as Tide detergent for $1, right? Look at these 3 laundry softeners, fabric softeners. I don't know why fabric softener has to come in a light blue bottle. You know, and the bottle shapes, not a lot you can do with a jug. Similar, confusing. All right, this is a slogan, the greatest show on earth, from the circus. And then Utah had, like the State Department of Commerce was trying to encourage people to ski Utah, so they called it the greatest snow on earth. Ringling sued them, and the court said nobody in their right mind would think that greatest snow on earth has anything to do with the circus. We get that it's cute and clever, no infringement. Yet, these shoes One is Guess, and I think the other is Forever 21. The red and green stripe is on a lot of the Guess items, and the court found that the look of this shoe was too close to the registered shoe design. I think that fabric design is registered and protectable. So it's not science, it's art. It's very mushy. Would a typical consumer think your trademark is similar to somebody else's trademark and can't tell who produced the product? So what can you do with trademarks? Somebody else's name. You can use them. Again, they don't have a monopoly. You can review a product and name the brand, compare brands. You know, I tried Kleenex tissues and I tried Puffs tissues when I had COVID, and here's what I found. Not related to trademark law, but related to Federal Trade Commission, online privacy, fair trade. If you were paid to review a product on your blog, you have to disclose your financial investment. If they paid you, if you got it for free, just so people know how, if you're being influenced. You can truthfully advertise that you sell a service or you sell a product, you service something. You can say, I'm a Microsoft certified repair technician. I repair Ford trucks. If you have permission to use somebody else's trademark, you know, you're a licensed distributor, you can use their trademarks. If you're using paid search terms and meta tags, you have to put that little ad symbol on your ad at the top of the Google results, because apparently we can't tell the difference between a paid response and a natural search. So I fix Fords, that's okay. We sell Levi's jeans, that's okay. So if you have some spare time, there's a song on YouTube called United Breaks Guitars by a guy named Dave Carroll. He was a musician and they made him check his guitar, and he looks out the window and sees the baggage handler chucking it down the tarmac from the plane to the baggage car to take it to the airport, and it got destroyed. And United, like, oh, we're limited to $200 baggage, it's in your ticket. And it was this, you know, however much professional guitar, and it was what more than that, but they made him check it and they gave him no satisfaction. So he made this song called United Breaks Guitars. It's really cute. It's 2009. It went viral and they ended up replacing his guitar. That's fair use. You know, all the, excuse my French, the suck sites, you know, Delta sucks, Walmart sucks. That's fair use of the trademark if it's opinion. So you can use other people's trademarks without infringing. What you can't do is name your business so close to their business that customers can't tell who is who. After you adopt your trademark, you have to police your trademark. It is up to you to make sure people aren't using it, other people aren't too close and potentially confusing your trademark for theirs. If you don't police it, you're going to end up like Kleenex, where every facial tissue, people call it a Kleenex, and you've lost your trademark rights. You are no longer distinctive in the marketplace. That's why it's so bad to become generic. So there's a lot of things to consider when you're working on infringement. You can either be like Jack Daniels or you can be like Starbucks. You need to pay attention to who is infringing and why, and how you write your cease and desist letter. So Starbucks has web crawlers that look for people that use their registered trademark names. And they found a little brewery called Exit 6 in a tiny little town and sent them their generic big law firm cease and desist letter. We represent Starbucks Coffee Co. And it is in its trademark matters. As you probably know, Starbucks Coffee Co. is the owner of a number of world-famous trademarks, including the well-known Frappuccino trademark. It says, you know, here's what we use it with, and here's the registration number. We have sold millions of drinks under this, and it's our valuable trademark and firmly associated. Has recently come to Starbucks Coffee Co.'s attention that Exit 6 Pub and Brewery is or was using the mark Frappuccino in connection with a stout style beer, and went on for 3 pages of really scary legalese about cease and desist. And they got this hilarious letter back from the owner. It was to Dear Ms. Owen Kramer, which was the lawyer, copy Mr. Bucks, as in Starbucks. And it went on to say, you know, we thought it would be funny to have a stout beer named Frappuccino, and the only reason we didn't make it identical to how you spelled Frappuccino is we're poor spellers. And we promised to not use the F word anymore because we don't want to get in trouble. And we've sold 38 drinks, and 3 people checked into a beer review website and liked our beer. And, you know, I know there's a Starbucks on every corner, but we honestly didn't think anybody would expect us to, you know, open the tap and pour coffee. And it was super mocking. And in the end, he sent the Starbucks company a check for $6, which was all their profits that they made on that beer. And people were mocking Starbucks for, like, clearly nobody thinks a beer called Frappuccino is actually coffee from Starbucks. And they were ridiculed in a lot of legal and business publications. Meanwhile, if you look on the other side, there's a Jack Daniel's label and there's a book cover that is very similar on purpose to the Jack Daniel's label. The Jack Daniel's lawyer, or their company had in-house counsel, sent a letter that sounded like this. We are certainly flattered by your affection for the brand, but while we can appreciate the pop cultural appeal of a Jack Daniel's, we also have to be diligent and ensure that Jack Daniel's trademarks are used correctly. Given the brand's popularity, it will probably come as no surprise that we come across designs like this on a regular basis. What may not be so apparent, however, is that if we allow uses like this one, we will run the very real risk that our trademark will be weakened. As a fan of the brand, I'm sure that is not something you intended or would want to happen. In order to resolve this matter, because you're both a Louisville neighbor and a fan of the brand, we simply request you change the cover design when the book is reprinted. If you would be willing to change the design sooner than that, we would be willing to contribute a reasonable amount towards the cost of doing so. Now, Jack Daniel's got a lot of publicity from that too, but it was all like folk hero. Wow, that's the coolest cease and desist letter we ever saw. So think about your brand. I've had clients that had pet-related businesses that they wrote all their terms and conditions from the point of view of their dog. And somebody lifted those terms and conditions verbatim and put them on another website. And that was one of those cases, it was copyright infringement, not trademark infringement, where you could tell they were flattered. You know, they thought it was really cool how the dog gave the terms and conditions of the website. And so when we were writing the cease and desist letter, we wrote it from the point of view of the dog. Hey, this is Snappy. I saw you got my stuff, you know, got to go back to training school. And they took it down immediately. And it was, you know, but if we had sent the Starbucks tone, it might not have gone so well. So just think about how you want to approach policing. And a lot of times people don't even realize they've taken your stuff. Questions?
There is a couple of comments. Some people have to leave, and they say thank you so much for the info. We're looking forward to the recording and the presentation if you will share it. And there was one comment here. I'm trying to find it. It was so She says, how can you increase your chances with I think she's meaning I love brand or I love you brand or a love brand when there are already so many trademarked? I mean, what is a good method to think about when branding something? Because there's already so much stuff out there.
We recently just searched a whole bunch of I heart blank. They're very, very hard. Because there are so many that are registered, you're just going to have to do a search and pay attention. And that's not going to be a super strong trademark because so many people use that theme. But you just have to find one that's not taken and that also is not only exactly, but in the same industry, it's not too close. Because like you can say I heart real estate if there's I heart realty or I heart real property or something. Like you're going to have to be really careful and thread that needle.
I displayed my ignorance there on what an I heart blank is. Thank you for that, Donna.
It's where instead of love, you put a picture of a heart.
I get it. Yeah. I don't see any other questions. If you have any other questions, go ahead and put them in the chat or come off mute. We have 4 more minutes. If you have something, might as well come off mute to ask. Thank you, everybody that's been here with us. It's been great. Great attendance, great questions, lots of good information. I would say if I have something to say on this, it's put this in your plan. Make sure you're budgeting your trademark costs, your protection, thinking about those items in your budget. There's a lot to think about when having a budget and starting a business or running a business. Your operational costs include a lot of different things that are hidden. Legal fees, using a lawyer for this kind of process is well worth it. They can help you investigate. They can help you understand what's worth doing. I have one more question here that just came in. With regard to policing your trademark, this clearly can get expensive. When do you go after someone?
Up to you. I mean, again, everything in business is cost benefit. You can go after them nicely for not a lot of money. Hey, I saw this. Here's my registered trademark. Please stop. I don't want to have to get lawyers involved. That really doesn't cost you anything. You just have to be dead certain you started using your trademark before they did. Because since you can get trademark rights just from using something, if you have a registration, but somebody predated your use, they're kind of grandfathered in. So it doesn't have to be expensive. I would put a Google search on my trademark and just be aware of, I have one on legal direction and I get a lot of hits, but they're all just like phrases in articles. A lot of them are like legal counsel hire is going to take our firm in the legal direction or, something like that. Nothing ever pops, but I have it. That's the cheap and easy way to do it.
Hi, I have a question.
I'm going to include, go ahead.
Hi, my name is Tamika McNeely. Is there any financial recourse if you file for a trademark and it's not approved?
No.
Okay, thank you.
Do your homework on the front end so you're not, your chances are better.
And we can we share this presentation, Donna?
Yes.
This with the trademarked items.
Everything I did was fair use, not to worry.
That's something to think about. Definitely. We have our next session is related to that. It's about social media and how that is going to impact your use of, images, pictures, whatever you use and post on social media. So check out our next session with Donna next month. I think it's midway through the month of August. Check our Eventbrite. It's on there. And I think that's it. If you're done, Donna, I appreciate
this
very much. Thank you so much. Thank you, everybody who was with us. Hope to see you all again and come visit Donna, come visit us and have a great rest of your day. Thank you so much.